The case began on December 16, 2025, when private chef Jamila Mila Adams accused NFL star Stefon Diggs of assault, battery, and strangulation during an alleged altercation at his Massachusetts home. According to her statement to police, the confrontation occurred during a disagreement involving unpaid wages, and she claimed that Mr. Diggs physically assaulted her. From the very beginning, however, Mr. Diggs denied every allegation. His defense maintained that no assault had taken place and argued that the accusations were motivated by financial interests rather than the events described in the complaint. Defense attorneys also asserted that the working relationship between the two had already ended and that Ms. Adams became upset after learning her services were no longer needed. As the investigation progressed, the defense pointed to surveillance footage and other evidence that they argued showed no visible injuries or behavior consistent with the allegations in the days following the reported incident. They also emphasized that what started as a disagreement over wages later developed into substantial financial
need to cross-examine the complaining witness.
The story that you just told to this jury under oath was very different from what you told to Officer Ellis. Do you agree with me?
Yes.
What you said to Officer Ellis when you reported this crime, this so-called crime, is that you had been having an ongoing text exchange over money owed to you.
Yes.
You told the police officer who filed the criminal complaint in this case, based on your word, that your fight with Mr. Diggs on December 2nd was over money. True?
Yes.
Except you just testified under oath to this jury that you didn't start talking about money until December 5th, right?
What did you say?
You just testified under oath to this jury.
I have been begging for my money since December the 5th. Mr. Diggs, and throughout those messages, you can see that I was begging for my money since that day.
Which message? Are you talking about Exhibit 3 that you just looked at?
It's other messages that you guys should have of me begging for my money from Mr. Diggs.
Ms. Adams.
Yes.
Do you recall testifying under oath to this jury that your fight on December 2nd was about Lindsay, your anger at Lindsay, and you being told you couldn't go on the Miami trip?
My anger was at Stefon. I never said my anger was at Lindsay.
You were angry at Stefon on December 2nd?
Yes.
Because you were told you couldn't go on
I was
Miami.
angry at Stefon because we were friends. And he told me at the last minute I could not go to Art Basel.
And yet when you walked into the police station on December 16th, you said you had been having an ongoing text exchange over money owed to you.
Yes, money owed to me after I asked Mr. Diggs on December the 2nd, when can I get paid?
Your Honor, may I approach? Do you recognize that document that I've shown you as the police report that was prepared based on your statements on December 16th?
Yes.
You've seen this report before?
Yes, I made it.
And you see on the report where it says, she said that on this date, the male that she worked for entered her unlocked bedroom. They had been having an ongoing text exchange over money owed to Adams. She said that they began to discuss this, which apparently angered the male.
I did not.
Question pending yet.
Oh,
do you see that
sorry.
language?
Yeah.
Did you say that to Police Officer Ellis on December 16th?
Yes, I see it.
And that wasn't true, was it?
To my recollection, it was true. We did discuss money and payment.
Ms. Adams, you just testified under oath about what happened on December 2nd.
Okay, I also didn't put in the police report our sexual relationship because I was ashamed. The police report got leaked. I didn't put a lot of things. The most important thing was the attack in the police report. Me reporting anything outside of why he got upset, I didn't feel the need to put it. I was scared of how it was received by the public. He's in a very public relationship with Cardi B. So I did not put a lot of things in the police report. My most important thing was him assaulting me and choking me and slapping me. So that was the most important thing that I put in the police report. I was very vague. I didn't feel the need that I had to go and explain the relationship.
When you were asked questions, you actually gave
I
false-
didn't feel-
Ma'am, you must wait until I finish the
Sorry.
question.
Wait until counsel has finished the question.
Oh,
If you
okay.
can answer it, answer it. If you don't understand it, ask her to rephrase.
Because you didn't feel it was important. When you were asked questions about what happened on December 2nd, you lied.
It did not change what happened on December 2nd.
I'm
It
gonna
did
try
not
my
change what happened on December 2nd. He choked and slapped me.
Ms. Adams, I'm going to try my question again. Because you didn't think it was important. When you asked the questions of Dedham Police Officer Ellis on December 16th, you lied.
I did not lie. I just did not expand on detail on the relationship I had with Mr. Diggs. I didn't feel that that was important. The sexual relationship, I didn't feel like that was important. I didn't feel it was important that he was upset because I told him I was not in love with him like those other women. I was ashamed of being with him.
Ma'am?
I didn't feel the
Ma'am?
need to explain it to the
Adams?
police officer.
Ms. Adams,
I'm sorry.
please answer the question so that counsel can then ask you the next question. All right?
Under oath, on December 2nd, when you claim Mr. Diggs walked into your room, you had not been having a text exchange fight over money.
The last text exchange fight was over money. The last text exchange was me saying, you need to pay me out for the rest of the season. I'm out of your life. Give me the money for my business in that order. That was the last text exchange. His response to me,
Well, ma'am, before we get to his response, why don't we get
you
to
will
what
be paying me out for the season and the money you said you would give me for my business. Wasted my, excuse my language, fucking time being here because you have a, excuse my language again, a fucking circus going on. I am out of your life. I am ruining that bitch life.
All right, Ms. Adams, you're going to listen to counsel's question. You're going to answer that question, and then you're going to wait for the next question. This is not an opportunity for you just to say whatever comes to mind.
Okay.
All right? It is to be responsive to the questions presented.
Okay.
Next question, counsel.
Thank you, Your Honor. That response that you just read, that was actually a response to something Steph wrote to you, right?
That was a text exchange over money.
No question, ma'am.
What was your question?
What you just read into the record, that was a response to a text message that Steph sent to you, correct?
Yes.
And in that request, in that message that Steph sent to you, you understood you were getting fired, right?
No.
What Steph wrote to you is, "I'ma leave you be. Thank you for cooking for me for this season. I appreciate you. Hate it even got to this, but oh well." Right?
Yes.
And you understood when you received that he was telling you you were not going to be cooking for him anymore.
No.
You didn't understand that.
No.
And that's why you responded with, "You will be paying me out the season and the money you owe me."
No.
Because you knew you were about to lose your job, right?
I was not about to lose my job.
You didn't understand, "I'ma leave you be. Thank you for cooking for me this season. I appreciate you. Hate it even got like this," as a sign that you were about to lose your job?
No.
Okay. In any event, you didn't tell Officer Ellis on December 16th when you reported this assault any of that, right?
The last text message was about money. The last back and forth text messages was about money. Money he owed me for not finishing out the contract, and money he owed me that he said that he would invest in my business.
So
I took a lower pay because Stefon agreed
Honor, may I have
that
the witness instruction?
I will have chance to work on my business by working with
Ms.
him.
Adams, there's no question in front of you right now. And again, please answer the questions put to you. It is not an opportunity for you just to vent with your story.
Defense counsel Sarah Silva
and
cross-examines
later,
Ms.
a
Adams.
demand letter seeking $5 million. When the case went to trial on May 4, 2026, Ms. Adams testified before the jury. After the prosecution completed its direct examination, defense attorney Sarah Silva began a detailed cross-examination aimed at testing the consistency of her testimony. Throughout the questioning, Ms. Silva compared Ms. Adams' courtroom statements with the account she had previously given to investigators. The defense argued that important details regarding the timeline of the wage dispute differed from what had been documented in the original police report. These differences became a central focus of the cross-examination. The defense also introduced text messages concerning the end of Ms. Adams' employment. While Ms. Adams testified that she did not believe she had been fired, the defense argued that the messages clearly indicated her employment had ended. According to the defense, this disagreement over the termination was significant because it could have influenced the events that followed. Another important point raised during the cross-examination involved text messages in which Ms. Adams acknowledged that additional payment was not necessary. Defense attorney Sarah Silva argued that these communications, together with other documentary evidence, raised questions about the consistency of Ms. Adams' account. The prosecution, however, maintained that her allegations remained truthful and supported by the evidence presented to the jury.
Of the
As the trial continued.
Thank you, Your Honor. May I proceed?
Yes, go right ahead.
We were just looking at an email, and you didn't remember, you said you hadn't received it in that form. If you can turn the page, did you see the invoice?
Yes.
And that was your invoice, right?
Yes.
And you said on that invoice dated December 1st, right?
Yes.
That you were owed payment of $2,000 for three weeks in November, right?
Yes.
And you were owed grocery reimbursement for $3,179.06, right?
Yes.
And that was what you submitted to get payment.
Yes.
And you said you didn't receive this email, but you remembered getting it by text message, right?
Yes.
Okay. And so you have read, and you remember seeing the substance of this email, true?
Yes.
Okay. And this is a response to your invoice, right?
I don't recall because Stefon was refusing to pay me for the week he sent me home.
Well, Melissa Goddard writes on December 4th, I appreciate you may not have received this on December 4th, but she writes, "Thank you for providing an invoice. I've attached a readable PDF."
Hang on.
Yeah. And it turned out, Ms. Adams, you had gotten paid for 2 of the 3 weeks that you said you hadn't gotten paid for, right?
This is missing a whole lot of stuff.
The yes or no question.
I can't answer your question correctly without the proper evidence.
Your Honor, may I approach?
You may.
Thank
Do you recognize this document as text exchanges between you and Sunny?
Yes.
Dated December 9, 2025?
Yes.
And you're the person in the bubbles on the left?
Yes.
And you write to Sunny, "Hey, so I looked over my transfers, payment history, and they sent payments, 11/7 and 11/21, totaling $4,000. See that?
Yes.
So you knew that you had actually been paid for 2 of those 3 weeks that you tried to get paid for again, right?
What's your name? I never got your name.
Did you know
I
that
don't
you
know.
had
I was trying to address you by your name because
Ms. Adams, did you
I'm
hear the
sorry.
question, and are you able to answer that?
I'm not this. I don't know. I can't answer that question correctly.
You knew on December 9th that you had been paid for 2 of the 3 weeks you said you hadn't been paid for, didn't you?
I don't understand the question.
You just acknowledged you wrote it to Sunny.
I was supposed to be paid for the week I was sent home. So
Okay.
I sent the incorrect amount because I didn't know he wasn't paying me for that week.
Right, so you sought $6,000 instead of $2,000.
That's my calculations was
Right. And so that last week, that was a week you didn't work, right?
because I was sent home.
Right, so you weren't in the kitchen cooking.
Mr. Diggs sent me home because he had girls at the
Ma'am,
house.
Whatever you're going to
I
add
should
is
be
not
paid.
responsive, Your Honor.
Yes. Ms. Adams, you
I'm
you
sorry.
understand the question you're being asked?
I don't understand.
Her question. Answer Attorney Silva's question, all right, if you can. If it's confusing to you, she will restate it. Counsel, did you restate your question?
Yes. So you weren't in the kitchen cooking that week, right?
No.
Okay. If you can turn back to tab D, the page that ends 171, this is Exhibit 4. It has been marked and admitted into evidence. Let me know when you get there.
I'm in D.
You there? Mm-hmm. So these are both, on this page, these are both blue bubbles. So this is your text messages, right?
Yes.
All right. And on December 9th, 2025 at 2:27, you text Steph Diggs, right?
Yes.
And what do you say to Steph Diggs
Hi,
on December 9th?
Hi.
Do you need help finding it?
What's the last?
171. I can help you find it if it would be easier.
I said, can she call?
I'm sorry, the second text message.
Read the second text message?
Yes, please.
Without reading the
You
messages
can read
before?
the first and we can talk about who you're asking about. That's fine.
I was told to contact Melissa about my pay.
Okay.
So I responded, can she call me or can I call her?
And Melissa, just so the record's clear, is Melissa Goddard, right?
Yes,
She's Steph Diggs' bookkeeper.
that's what I was told.
She's the person who wrote that email on December 4th informing you that you had been already paid for 2 of the 3 weeks you were looking for, right?
I didn't receive that email.
Understood. So you were asking if she could call you or you could call her, right?
I was told to
You were
reach out to
told you
her.
could talk to her, right?
Yes,
And you never called her, did you?
yes, I did.
What did you say in the second
I
text
asked him
bullet?
for the number.
I'm sorry, and
I
what did
asked him for Miss Melissa Goddard's number.
the number is right on the email that you got in text form.
But that was later time.
This was December 4th. The email is from December 4th. The text message you're about to read is 5 days later, December 9th.
What I'm trying to say to you is that text message was sent at a later date to me.
On December 9th, you acknowledged to Sunny that you knew you had been overpaid. I'm sorry.
Overpaid?
I'm sorry.
Underpaid.
You knew that 4 of the $6,000 you were seeking, you had already received. And the last week that you hadn't been paid for was the week you weren't there.
As the cross-examination continued, defense attorney Sarah Silva shifted her attention to what she described as inconsistencies surrounding Ms. Adams' financial demands. The defense argued that the evidence showed Ms. Adams had already received payment for her work, yet she continued requesting additional compensation. According to the defense, this pattern suggested that the dispute had evolved beyond a simple disagreement over wages. Building on that argument, Ms. Silva questioned whether the repeated financial demands reflected a genuine employment dispute or an attempt to secure a larger monetary settlement. Throughout the questioning, the defense maintained that these circumstances could indicate a financial motive, a factor the jury was entitled to consider when evaluating witness credibility. The defense also confronted Ms. Adams with an alleged statement she made to her former co-worker, Shai Charles, in which she reportedly discussed filing a lawsuit against Mr. Diggs. According to the defense, this conversation supported its position that legal action had been contemplated before many of the later financial demands were made. To reinforce its argument, the defense introduced payment records showing that Mr. Diggs had transferred $2,000 through Apple Pay and later provided another $2,000 in cash for Ms. Adams' final week of employment. Defense counsel argued that these transactions demonstrated that the agreed wages had already been paid. Additional text messages were presented in which Mr. Diggs repeatedly asked whether any outstanding balances still existed. During questioning about a grocery reimbursement request, Ms. Adams acknowledged that some of the receipts supporting the claim were incomplete or inaccurate. The defense argued that this weakened the reliability of her reimbursement request and challenged the allegation that she had been denied compensation. At the end of the day's testimony, Judge Carroll recessed the trial. Proceedings resumed the following morning, May 5th, with Ms. Adams returning to the witness stand for further cross-examination. Ms. Silva continued examining the increasing financial demands made throughout the dispute, arguing that the changing amounts were consistent with the defense's theory that the conflict had become primarily financial in nature. The prosecution, however, continued to argue that Ms. Adams' allegations were truthful and supported by the evidence presented during the trial. As the cross-examination moved forward, the defense turned its attention to the financial negotiations that had taken place before the criminal trial. Defense attorney Sarah Silva argued that, although settlement discussions are often restricted in civil cases, they may be considered in a criminal case when they help explain a witness's possible bias, financial interest, or motive. Using that argument, Ms. Silva presented what she believed were three important points for the jury to consider. She argued that Ms. Adams repeatedly sought substantial financial compensation, that criminal allegations became intertwined with those financial discussions, and that the amount eventually demanded far exceeded what the defense believed could reasonably be connected to the underlying dispute. According to the defense, these circumstances suggested that the conflict had evolved into an effort to obtain a large financial settlement rather than simply resolve an employment disagreement. Ms. Adams disagreed with that interpretation and testified that she could not discuss the multi-million-dollar demand because the matter involved communications with her attorney. Defense counsel challenged that position, arguing that once a demand letter is delivered to the opposing party, its contents may become relevant in litigation and are no longer shielded in the manner suggested by the witness. Ms. Silva further argued that the documentary evidence appeared to conflict with Ms. Adams' earlier statements that she had never sought money from Mr. Diggs. Throughout this portion of the trial, the defense maintained that these inconsistencies were important for the jury to evaluate when determining the reliability and credibility of Ms. Adams' testimony. The prosecution, however, continued to argue that the witness's account was truthful and that the evidence supported the charges brought before the court. In the final stage of the trial, the defense emphasized what it described as a dramatic shift in Ms. Adams' financial demands. According to defense attorney Sarah Silva, the progression from an initial request of $19,000 to a later demand of $5 million was a significant factor that the jury could consider when evaluating the credibility of the witness. The defense argued that these increasing demands reflected a possible financial interest in the outcome of the case. Throughout closing arguments, Ms. Silva maintained that the jury should carefully examine whether the witness's testimony remained consistent with the documentary evidence presented during the trial. She argued that the changing financial requests, together with the text messages and payment records, created questions about the reliability of the allegations. After both sides completed their closing arguments, the case was submitted to the jury. Following less than 90 minutes of deliberation, the jurors returned a unanimous verdict finding Stefon Diggs not guilty on every criminal charge, including felony strangulation and misdemeanor assault and battery. With that decision, the two-day criminal trial officially came to an end. The proceedings highlighted the critical role that witness credibility can play in a criminal courtroom. During cross-examination, the defense repeatedly pointed to what it believed were inconsistencies between Ms. Adams' testimony, her prior statements, and the financial demands made throughout the dispute. According to the defense, those inconsistencies suggested that financial considerations may have influenced the allegations. The prosecution, however, continued to argue that Ms. Adams' account was truthful and that the evidence presented at trial supported the charges. Ultimately, it was the jury's responsibility to weigh the testimony, review the evidence, and determine whether the prosecution had proven its case beyond a reasonable doubt. After considering all of the evidence, the jury returned verdicts of not guilty on all counts. Thank you for watching. If there's another courtroom case you'd like us to cover, let us know in the comments below. Be sure to like this video, subscribe to the channel, and turn on notifications so you never miss our next in-depth legal case analysis. In the final stage of the trial, the defense emphasized what it described as a dramatic shift in Ms. Adams' financial demands. According to defense attorney Sarah Silva, the progression from an initial request of $19,000 to a later demand of $5 million was a significant